Welcome back, guys. In this session, we're going to look at constitutional law and the kind of questions that you can expect in CLAT. We're not going to be so much discussing the questions. We're more going to be discussing issues and aspects of constitutional law that are relevant to CLAT. Okay. Now, in this section of the legal reasoning paper is unique because not only will you be required to apply legal reasoning, but you will also be expected to know certain things about the Constitution, which we will discuss. Hence, this section will test both your legal reasoning as well as legal knowledge. Okay. Now, the Constitution is the fundamental law of the land. All other laws have their basis in the Constitution. That is, no other law of the land passed by Parliament, no other law of the land can contravene the provisions of the Constitution. No interpretation of law done by the courts can contravene the provisions of the Constitution. The Constitution is supreme. Okay? Thus, aside from the provisions of the Constitution, one also has to understand the reasoning behind these provisions. Because oftentimes, while interpreting the Constitution, the courts have looked into the reasoning behind why certain things were included in the Constitution, why certain things were left out. Okay? Now, the constitutional document begins with the preamble. The preamble does not itself grant any powers, but sets out the aims and aspirations of the people of India, which have been translated into various provisions of the Constitution. Thus, the preamble, which was drafted after the draft Constitution was approved, expresses the philosophy of the Constitution. So, the preamble is basically taken to be a legitimate tool to interpret the Constitution, but it is not. There was for a while there was ambiguity as to whether the preamble should be considered part of the Constitution or not, but that has been settled. I think we'll come to that in a little bit. Now, we've discussed Austin's command theory of law, which says that law is command of the sovereign backed by sanction. So basically, in the Indian situation, is the Constitution to be considered the sovereign, as it is the supreme law of the land? Now, the problem there is a document cannot be considered as sovereign. A document cannot be considered as someone who is issuing laws. So here, the words in the preamble that we the people give to ourselves this Constitution represents that the people of India are the sovereign. That all laws ultimately have their source in the people of India. Okay, so this is just a technical thing, but just keep this in mind. Thus, while the preamble itself does not grant any powers, it can be seen as a legitimate key to interpret the mind of the makers of the Constitution. Okay? Now, the preamble was enacted and adopted using the same procedure as the rest of the draft Constitution. Thus, in the Keshavananda Bharti case, the Supreme Court held that the preamble is part of the Constitution, doing away with ambiguity over its status. As we mentioned before, there was some ambiguity as to whether the preamble is to be considered part of the Constitution or not, but this was done away with in the Keshavananda Bharti case. Now, the preamble first clarifies that India is a sovereign, socialist, secular, democratic republic. Okay, sovereign because no other country dictates to India what to do. India is the master of her own destiny. Okay, socialist because we have a welfare state model, okay, where we look after the interests of the poor. Secular because there is no state religion and every citizen, every person in India is free to practice their own religion, free to practice, profess, propagate their own religion. Democratic because we periodically elect into power our government, okay, and a republic because we are a republic nation, okay. Now, the preamble secondly states out the aims of the Constitution, that is to secure social, economic, and political justice, liberty of thought, expression, faith, and worship, equality of status and opportunity, and fraternity, assuring the dignity of the individual. Thus, the aims that the preamble sets out in the Constitution are justice, liberty, equality, fraternity. Okay? The preamble thirdly makes clear that the Constitution emanates from the people of India and not from another source. That is to say, we give ourselves this Constitution. Okay, so while we are setting the Constitution above us as a source of laws, as the basic source of all laws, it is we who are doing that. So it clarifies that basically the people of India are the sovereign. Okay. Now, the kind of questions that you can expect in the CLAT paper tend to be from the fundamental rights section of the Constitution, that is part 3 of the Constitution. Part 3 and part 4 deal with the fundamental rights and fundamental duties, And this is basically the human rights regime envisioned within the Constitution. Okay, so we will be looking at the provisions of Part 3 of the Constitution in greater detail so that you have an idea of the kind of questions to expect when dealing with the CLAT paper. Okay, now the fundamental rights is basically the Charter of Rights contained within Part 3 of the Constitution of India. It guarantees civil liberties such that all Indians and also persons living within India can lead their lives in peace and harmony as citizens of India. Okay? By and large, fundamental rights are guaranteed to all citizens of India. However, certain fundamental rights are also guaranteed to persons who are not citizens of India but merely residing in India. We'll discuss in greater details which ones are applicable to citizens of India and which ones are applicable to all persons within India. Okay? Now, there are 6 essential fundamental rights which are guaranteed by Part 3 of the Indian Constitution. The right to equality, the right to freedom, the right against exploitation, the right to freedom of religion, the right to cultural expression and education, and the right to constitutional remedies. Okay? Now, let's take a sample question. Okay? This is the kind of question you can expect in CLAT. Okay? Facts. Ranjit Singh, a resident of the state of Punjab, is denied admission in a premier government institute on the basis that he is a non-resident of Maharashtra. Ranjit Singh has decided to challenge the constitutional validity of this rule. Principle: the state shall not discriminate against any citizen on grounds only of place of birth. Okay? So which do you think will be the answer in this case? Now let's look at the facts once again. Ranjit Singh, a resident of Punjab, is denied admission in a government institute on the basis that he is a non-resident of Maharashtra. So the basis on which he is denied admission is that he is a non-resident of Maharashtra. It doesn't have to do with his place of birth. The principle states that the state shall not discriminate against any citizen on grounds of place of birth, on grounds only of place of birth. Okay, there may be other grounds upon which the state may discriminate, but on grounds of place of birth, the state may not discriminate. Now, in this case, Ranjit Singh is basically discriminated against on grounds of his residency, on his place of residency, not so much on his place of birth. Okay, thus the answer in this case will be C. Okay, Ranjit Singh will not succeed since the discrimination is a valid one. Okay, so this is the kind of question you can expect. Now, as you noticed in this previous section, the rights that are guaranteed are essentially guaranteed against the state. The fundamental rights are guaranteed against excesses of the state, and the state is made responsible for guaranteeing them. Thus, it becomes important to look at the definition of what is state. Article 12 includes under state the government and parliament of India, the government and legislatures of the states, all local authorities, and other authorities under the control of the government of India. Now, the definition of state under Article 12 is inclusive and not exhaustive. That is to say, these 4 elements that have been mentioned under the definition of state are definitely part of what constitutes state, but there are other entities that also may constitute state. Okay? Thus, the courts have expansively defined state. Under other authorities, the courts have also included all authorities created by the Constitution or by statute on whom powers are conferred by the law. Okay? This has also been held to include public corporations, since they could make binding rules and regulations and are subject to the pervasive government control. Now, public corporations are basically corporations where the government holds 50% or more of the shareholding. That is to say, they are the controlling authority behind the public corporation. Okay, now public corporations, since they can make binding rules and regulations, are also held to be included under the definition of state. Now we look at the right to equality enshrined in Articles 14 to 18. Article 14 states that the state shall not deny to any person equality before the law or equal protection of the law. Now, Article 14 is basically how most constitutions define the right to equality, that is, as a negative right that denies unequal treatment by the state. The Indian Constitution goes beyond this, okay, also takes into account existing inequalities in society. Thus, under Article 14, all persons and things similarly circumstanced shall be treated equally or alike, both in respect of privileges conferred and liabilities imposed. That is to say, it does not forbid different treatment of unequals. Okay? So persons who are basically placed differently, okay, the law may make a reasonable classification between persons, okay, who are placed differently, so long as there's a reasonable basis for such difference. Say for instance, between minorities and the majority of the majority community in the population, okay, the law may make a differential basis of classification between the two. Such classification alone does not make the law contravene the provisions of Article 14. Okay? So what is reasonable classification? For the classification to be valid, it must be founded on intelligible differentia which distinguishes between persons or things that are grouped together or left out. The differentia must have a rational reason to the object sought to be achieved by the statute in question, and the object of classification must be lawful, that is, they must be made with the utmost good faith and must have direct and reasonable relation with the object sought to be achieved. So these are the basis on which any statute can make reasonable classification between persons or between groups of persons. Okay? So basically under Article 14, arbitrary actions are held to be violative of the principle of equality enshrined in the Article 14. This was held by the constitutional bench of the Supreme Court in the Ajay Hasia case. This principle of reasonable classifications has been subsequently applied across a variety of cases and become part of the law relating to Article 14. So basically, whenever you'll be given a principle that relates to Article 14, you may have a case of reasonable classification, say for instance, between say persons, normal persons, and say special groups such as women or disabled persons or minorities, okay, or religious minorities or regional minorities, okay, and in that case, such differentia will be considered reasonable, okay. Now, Article 15, which also deals with the right to equality, deals with the prohibition of discrimination and says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Okay, Article 15 also provides for no discrimination in access to public spaces such as shops, hotels, places of public entertainment, the use of tanks, wells, and roads, etc. Okay. However, Article 15 saves special provisions made for the empowerment of women and children, as well as scheduled castes and scheduled tribes. Okay, so while the state is not allowed to discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, okay, there's a special saving of any provisions made for the empowerment of women, children, scheduled castes, and scheduled tribes. Okay, so this again becomes a reasonable classification for the state to provide positive discrimination for these special groups. Article 16 provides for equality of employment and equality of opportunity. Okay, Article 16 provides also for non-discrimination in matters of public employment. So private employers are free to have discriminatory, again, this is subject to a lot of case law, but for public employment expressly in the Constitution, there is a provision for non-discrimination, okay? Now basically Article 16 is an instance of the application of the general rule of equality under Article 14 applied to matters of public employment. Once again, the article saves any provision made for the benefit of backward classes and scheduled castes and scheduled tribes, okay? Now we come to one of the meatier sections of the fundamental rights, that's part 3 of the Constitution. That is to do with Article 19 of the Constitution, which deals with the right to freedom. Okay, Article 19(1) guarantees 6 freedoms: the freedom of speech and expression, the freedom to assemble peacefully, the freedom to form associations or unions, the freedom to move freely throughout India, to reside and settle in any part of India, to practice any profession, or to carry out any occupation, trade, or business. Okay, now these are all the part of what is called the Charter of Rights available to a free man. If you may have heard of the Magna Carta, that's where essentially all of these freedoms were first contained. The Magna Carta The Magna Carta was drafted in the 12th century in Europe, basically as the rights of free men. Okay, these are basically the basic rights recognized as natural rights enshrined in the status of any citizen. It may be noted, however, that none of these rights are absolute. Clauses 2 to 6 of Article 19 provide for conditions whereby the rights under Article 19(1) may be restricted or curtailed. So basically, Articles 19(2) to 19(6) provide for reasonable restrictions, but nowhere is it defined what is reasonable and under what conditions are restrictions considered to be reasonable. Thus, there is no general or objective standard, and the test must be subjective. Okay. However, certain guidelines have been developed over time by the courts. Okay, one of the main ones is that the restrictions must not be excessive and balance the needs of the freedom under Article 19(1) and the restrictions in Articles 19(2) to 6. Okay. The restrictions imposed must be both substantially as well as procedurally reasonable. That is to say, the restriction imposed must not only be reasonable in terms of the letter of the law, but also in terms of how it is implemented. Okay, the law imposing the restrictions may be reasonable, but the restrictions themselves may not be. Okay, in which case they fall short. Okay, that is to say for instance, there's an instance of a lot of terrorist activity which is emanating from one state. The law, in this case, if there is a law that is imposed which restricts residents of that state from moving freely across the rest of India, okay, so that contravenes one of the provisions of Article 19(1). Okay, thus the philosophy behind the law itself might be reasonable, but the restriction itself is excessive. Okay, in which case it falls foul of the reasonableness of the restrictions. Okay, and restrictions imposed in favor of a directive principle of state policy will be considered as reasonable. Thus, you can have a law which, say for instance, provides for restriction of cattle slaughter. Okay, one of the directives of principles of state policy basically provide for the restriction of cattle slaughter. So, if a law is enacted which restricts the kind of food you can eat, okay, this will not be held to be violative of Article 19(1). Okay. Now, Article 20 is another one of the key provisions from which CLAT questions are asked. Article 21 provides for protection against conviction by laws enacted subsequent to a certain action being taken. Okay, that is to say that you can only be convicted for an action which is illegal at the time that you're committing that action. If subsequent to your taking that action, there's a law put in place which makes that action illegal, okay, then you cannot be held liable under this subsequent action. Say for instance, the enactment of the TADA. Now, why was the TADA put in force? Because certain activities were seen as violative, as problematic and requiring restriction. So the TADA was enacted. However, if you've committed that action before the TADA came into force, then you cannot be held guilty under the TADA. Okay. Article 21 states that no person shall be convicted of any offense except for violation of law in force at the time of commission of the act charged as an offense, nor be subjected to a penalty greater than that might have been inflicted under the law in force at the time. So this basically provides for protection against conviction of laws that are enacted subsequent to the commission of a certain act. Okay, Article 22 contains the rule against double jeopardy. Article 22 states that no person shall be prosecuted and punished for the same offense more than once. Now, key to this is no person shall be prosecuted and punished. Okay, so if the first action that was taken against the person was not in the nature of a prosecution, that is, the person was not charged with a crime and tried for that crime, then the person can be subsequently charged and tried for that particular offense. Okay, the rule against double jeopardy is based on a common law maxim. Okay, but since it has been enshrined into the constitution, it basically gains a greater status. Okay, and basically, so there must have been prior judicial proceedings for this law, for this provision to apply. Okay. Now, Article 23 provides the prohibition against self incrimination. It is similar to the Fifth Amendment in US law. So if you've seen American Hollywood movies where they plead the fifth. Basically, it is the right pertaining to a person who is an accused and states that the person cannot be forced to bear witness against himself. Okay, it is a protection against compulsion to be a witness against yourself in a matter where you are being tried. Okay, so basically, it provides a protection to a person charged in an offense against giving evidence against himself. Okay. Now we come to one of the other major provisions of the Constitution, of the Fundamental Rights section, from which questions are asked in CLAT all the time. This is Article 21 of the Constitution, which provides the guarantee to every person of life and liberty. Okay. Article 21 states that no person shall be deprived of his life and personal liberty except according to procedure established by law. That is to say, no one can arbitrarily deprive you of your life or personal liberty. Now, the term life has been held to mean more than mere animal existence and includes the right to live with human dignity. And it is under Article 20, under the right to life, that the Supreme Court has often upheld such actions such as petitions against injurious drugs, petitions seeking human conditions in care homes, that is old age homes, the right to relief in case of harmful environmental pollution, and even the right to livelihood. Okay? The right to personal liberty has been used to uphold the right to be free from constant police surveillance, and most recently, in the Aadhaar case, it has been argued as the basis for the right to privacy. Okay? So the right to life has been read expansively. It's not just existing, it's not just mere animal existence, but it is right to life with personal dignity. Okay? It also becomes important to examine the expression procedure established by law. The essential ingredients there are that there must be a law justifying interference with personal liberty, the law should be valid, and the procedure laid down in the law must be strictly followed. The provision was narrowly defined during the emergency, but it has been subsequently defined more expansively by the courts. Okay. Now, Article 22 again is similar in nature. It provides for the rights of a person being arrested or detained. Article 22(1) provides that no person who is arrested shall be detained in custody without being informed of the grounds of his arrest, nor shall he be denied the right to consult a legal practitioner of his choice. Article 22(2) states that every person who is arrested shall be produced before the nearest magistrate within 24 hours. So Article 22 basically deals with the rights of persons who have been arrested or detained. Okay? Article 22(4) states that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless certain conditions are satisfied. So preventive detention is basically a case where you have not actually committed a crime, but the state suspects that you may commit a crime or you may be involved in certain illegal activities. Okay, so you are put in detention preventively. That is to say, to prevent you from taking those actions. Okay, so the Constitution, Article 22(4) of the Constitution states that no law providing for preventive detention shall authorize the detention of a person for a period longer than 3 months. Okay, and Article 22(7) states that Parliament may make a law providing for a longer period of preventive detention. Okay, so as long as Parliament has not made such a law, 3 months is the limit to which a preventive detention action may be sustained. Okay. Now, there are other fundamental rights which are also may form the basis of a CLAT question. Article 23 contains the right against human trafficking and forced labor, while Article 24 contains the right of children not to be employed in factories, mines, or other hazardous employment. Article 25 contains the right to profess, practice, and propagate any religion of one's choice. Article 26 provides for the rights for the adherents of a religion to administer and manage their religious affairs. Okay. Article 27 provides for the freedom of payment of taxes whose proceeds are to be used for furthering any particular religion. Article 28 provides for the conditions under which religious instruction may be provided at educational institutions maintained out of state funds. Article 29 states that any minority group with their own distinctive language, script, or culture shall have the right to preserve it. Article 30 provides for the rights of religious or language-based minority groups to establish and administer educational institutions, while also providing for the protection of such institutions in the disbursements of state funds. Article 31 used to deal with the right to property, but it has been abolished under the 44th Amendment. Finally, there are writ remedies available under the Constitution, under Part 3 of the Constitution. Article 32 provides for the judicial safeguard against abrogation of the fundamental rights contained in Part 3. That is to say, if any of your fundamental rights under Part 3 have been abrogated, the state has violated any of your rights under Part 3, you can approach the Supreme Court. Article 32(1) guarantees the right to move the Supreme Court for the enforcement of rights conferred by this part, that is Part 3. Article 32(2) states that the Supreme Court shall have the power to issue writ remedies to remedy any abrogation of fundamental rights. Now, what are these writs? The writs basically available to the Supreme Court are 5 of them. There are 5 of them. They are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Habeas corpus is where you are required to produce the body of a certain person or to produce a certain person before the court. Mandamus is basically where the state is required to take certain action. Prohibition is where the state is prohibited from taking certain action. Okay, the writ of quo warranto is basically a writ whereby the court can inquire as under what warrant or under what authority a certain state officer or a certain state office has undertaken a certain action. And certiorari is basically a writ by which the court can pull up matters from the lower courts and examine them. Okay, Article 32(4) states that the right guaranteed by this article shall not be suspended except as provided by the Constitution. That is to say, it's only in cases of emergency that the rights under Article 32 can be suspended. In all other cases, the writ remedies are available before the Supreme Court. Okay? So this was a brief look at the kind of topics you can expect to be covered from the CLAT question paper. Okay? I would suggest that you practice as much as possible. Okay? In the next section, we will look at contract law and the principles of contract law that are often used to ask questions in the CLAT paper. Subsequently, we'll move on to criminal law and the law of torts. Okay? So good luck, practice hard, and see you next time. Bye.